What should I do if my I-751 gets denied? Hi, I'm Jim Hacking, immigration lawyer practicing law throughout the United States at our offices in St. Louis, San Diego, and Washington, D.C. For those of you who don't know, all we do is immigration at Hacking Immigration Law, hence the name. And within immigration, the vast majority of what we do are marriage-based cases, whether they're overseas cases, 751s to remove conditions, adjustment of status cases here in the United States, citizenship, asylum. We do a fair amount of employment, and we have lawyers in the office who sort of specialize in that. But mostly what we do are help married couples stay together in the United States. And so we file a ton of I-130 cases, adjustment of status or overseas immigrant visa cases. And because of that, we often end up helping our clients through the I-751 process. That's the petition for removal of conditions. So just as a refresher, if you receive your green card based on marriage, and if that marriage is less than 2 years old at the time the green card is issued, then you're going to need to file a form called an I-751 petition for removal of conditions around the 1 year and 9 month mark of the start date on your green card. You have that 3 month window from 1 year and 9 months after your green card was issued up until 2 years of having your green card issued. You're going to need to file your I-751, and you're going to need to basically reprove your marriage all over again. This is one of the ways that USCIS tries to cut down on marriage fraud. They make people get a conditional green card and then file for what's called removal of those conditions. And you do that by filing the I-751 and submitting lots of evidence. And so a lot of times a initial green card, a conditional green card is approved without a ton of marital evidence. They sort of understand that maybe the couple was living apart, maybe the couple was separated and one member was overseas, or maybe they were just recently married. So they might not have a lot of evidence at the initial stage. Of course, when we're doing an I-130, we want to submit all that we can, but USCIS sort of holds marriages to a higher standard the second time around. In other words, they want to make sure that you're sort of living together as spouses, that you are commingling your assets, that you're buying things together, that you're taking trips together, that you're building a life together like a quote-unquote normal married couple would do. And so when you file that I-751, you don't want to take it too casually. I was talking to a former client the other day who decided to do a 751 on his own, and he basically screwed it up, and it got denied. And so now we're having to scramble to actually it got a notice of intent to deny. So he hired us to help with that. We're going to have to scramble to try to get the case approved, and he's going to end up paying more money because he didn't file the strongest case at the beginning, and I think maybe at his interview he took it a little too casually. In any event, if your I-751 is denied, and hopefully his will not be denied, sometimes they quickly refer your case to the immigration court. I was talking to someone on my Immigration Answers show on YouTube yesterday about this. It's pretty rare, actually, that the knee-jerk reaction of USCIS when your I-751 is denied is to send your case to the deportation court. So let's walk through how this would happen. So typically, you and your spouse file the I-751 together. You submit all your evidence. You may get an interview. I think only about 10% of the cases actually have interviews. And most of these cases are approved. You can also file on your own if your marriage is over and you can prove that it was a good faith marriage, or if there's been abuse or something like that, you can file an I-751 on your own. But to that point, when USCIS issues its decision, the vast majority of people wait 2 years for USCIS to decide the case, but then they're right on track for citizenship. For that limited number of people who get a denial of their I-751, I would say maybe 1 out of 20, 1 out of 25 get immediately referred to the immigration court. And we've handled those cases, not necessarily for I-751s that we filed, but I-751s that we sort of took over and are trying to help the people after a denial. And obviously you need to move quickly, because USCIS can always refer that immigrant whose 751 was denied over to the immigration court. Now, what I would do if I were hired to help someone after the denial of an I-751, I would, of course, file a stronger case, and I would file that as quickly as possible. There's no real way to appeal the denial of the I-751. You do have the chance to prove up that marriage in the immigration court, but with the severe backlogs at the EOIR, the Executive Office for Immigration Review, which is the formal name of the immigration courts, with the excessive delays that are happening there, what we do is we file a new 751 with USCIS. Sometimes the the 751 was originally filed jointly and now there's been a divorce. So there's like a fundamental defect of filing it together. But in any event, we're going to go back and file the strongest case possible. We're going to document the entire marriage. We're going to talk about the entire relationship. We're going to get a long affidavit from our client explaining the ins and outs of the marriage, why it was love, why it was real, why it sort of fell apart, and sort of walk them through that. We might even try to get a similar, smaller affidavit from the U.S. citizen spouse who petitioned originally for the green card. Now, you want to get that thing on file as fast as possible. Many, many times USCIS will issue you that new extension letter of your status. And so even though they just denied it, they'll receipt in the 751. And you need to do that for a couple of reasons. One is you want to protect yourself and try to stay in status as much as you can. And also, I think that would cut down on the chances of you getting referred to the immigration court. And then if you do get referred to the immigration court, we've had several cases where that happened, where we went to the judge and we said, Judge, look, you guys are really backlogged. We did the research, and it looks like USCIS can still approve the 751. You can keep this case on your docket, but just roll it 6 or 12 or 18 months and let us file the new 751. Let us submit the strongest case possible. Then, Judge, you won't have to deal with this. You won't have to handle this case. You can just move on to all your other deportation cases. Really nothing to see here. And that strategy has worked several times for us. So don't assume that just because your 751 was denied by USCIS that you can't refile. Don't assume that only the immigration judge can approve your 751, and really do everything you can to get it approved on your own without the involvement of the immigration court. Then once that 751 is approved, you go back to the court and you ask the judge, hey, Judge, this 751 has been approved. Can we terminate proceedings? And so that's how we handle it. That's the best strategy for you, and that's really what you need to be thinking about when it comes to your 751 once it's been denied. I hope you found this helpful. If your 751 is on the rocks, or if you're getting ready to file a 751, or you want to file a strong marriage case or a strong 751, feel free to give us a call at 314-961-8200. You can also email us info@hackingimmigrationlaw.com. Be sure to join us in our Facebook group. It's called Immigrant Home. We'd love to have you there. There's thousands of immigrants talking about the immigration process every day. You can also follow us on TikTok @ImmigrationHacking. And then, of course, we have our YouTube channel where I have thousands of videos talking about the immigration process. Every question you might ever had is probably in there on a video or on our Immigration Answers live show, which you should join us 3 or 4 times a week. I go live trying to answer as many immigrant questions as I can to help people learn about the process, learn about what they're up against in going through immigration. Thanks so much, and we'll see you next time.